Well, folks, Trump's Save America Act just got a court deadline, and now the Senate has no excuse. August 3rd, that's the date. Now, if the courts can take the election integrity fight seriously, Senate Republicans can now stop treating it like they have a scheduling problem. Now, the Supreme Court docket has the date this whole fight turns on, August 3rd, 4 p.m. That is the response deadline in the Trump admin's emergency application over the election integrity executive order. The court has not handed Trump a final win yet. It's not passed the Save America Act from the bench, but it's put the fight on a real institutional clock. Now, this matters because Washington loves hiding behind process. The Senate can always say the timing is wrong, the votes are difficult, the rules are complicated, the calendar is packed, the recess is coming, the parliamentarian may object, the filibuster. Everybody just needs to wait. But now the court system has things moving. The Trump administration filed the emergency application on the 27th. August 3rd is the response. That's the docket. And today, the AP reported that a D.C. Circuit panel declined to block Trump's mail voting order in a separate case. So we now have two tracks moving at once. One court track didn't accept the immediate block theory. Another court track is already in front of the Supreme Court on emergency relief. That is the part a lot of people are not getting here. Okay, they're going to treat this like another legal update, another headline, another Trump court fight, another technical argument over federal elections, but it's bigger than that. This is the justice system weighing in, forcing the same question that the Senate keeps trying to dodge. Are we going to secure our federal elections? Are we going to verify citizenship, tighten the mail-in ballot rules, and protect the vote? Or are we going to let procedure become an excuse? Now, for regular Americans, this lands in a very simple way. Why is this so hard? This is the whole reaction. Why is citizenship verification treated like some impossible burden only when the subject is voting? And if we have to prove who we are to go to work, to bank, to fly, to buy medicine, to walk into secure buildings, to deal with the government, the basic normal things in life that adults do every week, then why does Washington, D.C. act like verifying our citizenship for federal elections is some radical concept? Because it's not. It's the American baseline. And that is why the courts and their deadline is serious. And it's dangerous for the John Thune Senate excuse machine. Because the issue is no longer sitting in some committee conversation where leadership can bury it under procedure and hope that regular people just stop paying attention. August 3rd has a date, a dinner date. Now, Democrats have to answer the Trump administration at the Supreme Court. Now, the courts are weighing the machinery. Now, Senate Republicans have to explain why the court can move faster on election integrity than the people elected to pass election integrity law. The tracks matter here, so we got to keep them straight. The D.C. Circuit Court and its development is one track. Okay? That's a legal development against the theory that this order needed to be frozen immediately on its path. Now, the Supreme Court emergency application is a separate track. That one's tied to litigation where implementation was blocked in 23 states and D.C. And the Trump administration is asking the relief court or the high court for emergency relief. Not the same case. One doesn't automatically control the other either, but together they show some momentum and some movement, a movement that can change the politics here. Because everything is frozen. Senators are pretending that their hands are tied. But the courts are moving now, and they have visible deadlines. The White House has put the mechanism on paper, and these delays are starting to look less like caution and more like comfort. And leadership in the Senate has to answer. Now, the executive order is not just a slogan. The White House laid out the machinery. DHS citizenship data is coordinated with the states. Postal Service procedures around mail-in ballots. Lists connected to mail ballot participation. Attorney General enforcement priorities around unlawful ballot activity and non-compliant jurisdictions. And that is why this connects directly to the Save America Act fight. The bill is a legislative aid of the same basic principle. Citizenship matters in federal elections, and the system should be built to prove it way before ballots are cast and counted. And Trump is pushing the issue through the executive branch and through the courts. Senate is where the law has to be made. And that's where the excuses keep showing up. John Thune. Not opposition, okay? Sometimes the excuse is the delay. Sometimes it's the procedure. Sometimes it's leadership acting like the calendar is more sacred than the country. And that's the part that none of us like, because we don't get to move like that. If we miss a deadline at work, there are consequences, okay? If we can't prove who we are, we don't get waved through some, metal detector or into a building because we had a busy calendar. But the Senate, somehow, their calendar becomes a shield. And that is why Trump is putting the pressure where it belongs. So let's not let anyone tell us the court fight and the Save America Act are separate stories. Okay, they're different tools aimed at the same problem. The court fight tests how much election integrity authority the Trump administration can exercise right now. The Save America Act is Congress putting the citizenship standard into law. One doesn't replace the other or excuse the other. If anything, the court in its fight makes the legislative fight more urgent because it proves the issue is live. And that creates the logic trap. If Democrats think the order is unlawful, well, they're already answering it in court. If the court thinks the issue is serious enough to move on the clock, then Senate Republicans cannot pretend the issue is not ready. If regular Americans understand the principle in 5 seconds, then the Senate should stop hiding behind a process explanation that takes 5 minutes and still lands nowhere. Not complicated. Citizens only should be able to vote. The government should be able to verify it. Ballot systems should be secure. States should not be allowed to run dirty systems and then act offended when the federal government asks basic questions before a national election. That has to be the standard. Now, if this is a useful breakdown to you, hit the subscribe button, folks, because as monotonous as this is, I have to cover it every day because we have to keep tracking these things. All right. If we don't, then nobody's going to hold these folks accountable. Now, the middle of the story is the part that can't let disappear. Okay. The Supreme Court deadline is not just a date for lawyers. It's a political pressure point because when August 3rd arrives, okay, the public cannot look at two things at the same time. Okay. Okay. What Democrats tell the Supreme Court about Trump's election integrity order and what the Senate Republicans are doing while that fight is active. Because that comparison is brutal. The courts are dealing with the issue. Trump is forcing it. Democrats are fighting it. Regular Americans understand it. But what the hell is the Senate doing? That's the question. And the answer, unfortunately, cannot be another excuse. Timing is the whole point here. 2026 midterms are not some distant academic exercise. Election rules have to be in place. Verification has to happen before the ballots go out. Machinery has to exist before the problem shows up. We cannot build election confidence after the fact. We have to build it before people go out to vote. That's why the Senate delay is so insulting. Not because every legal question has already been decided. It's because the Supreme Court has already, or because the Supreme Court has already ruled for Trump. Because the court system is treating the fight as live and the Senate is still acting like the public should wait quietly while they manage their stupid schedules. The America First demand is simple. Save America Act and its fight needs to happen while the court clock is active. Name the holdouts, count the votes, state the obstacles out loud. If the filibuster is the excuse, name it. If the senators and the Republican side are the excuse, say it. If leadership doesn't want the fight before recess, good luck. But stop insulting regular people by pretending that this verification process is confusing. It's not confusing to any of us who have to show ID in our everyday lives. It's not confusing to the veterans who watch this country spend decades verifying everything except for one thing that decides who governs them. Not confusing to candidates who have watched election rules become the battlefield before a single vote is cast. Courts are not finished, okay? Supreme Court may grant relief, deny it, narrow it, or ask for more briefing, or do something that nobody can predict. But Senate excuse, it changed the moment the court clock appeared. August 3rd is the date. No excuse is the standard. John Thune, get it done, dude.